we talk a lot about parenting time, but and that's for guardians. And I want to talk, though, about contact, because I know this comes up a fair bit, because contact is for folks who they're not guardians, so they're a parent and they're not a guardian. But often it's who else? It's a grandparent, or an aunt or an uncle, or friends even. Anyone can seek contact, right? So I think it's sometimes important. I mean, parenting time, parental responsibilities, I think you've done lots of cases around that. So I think a lot of, the factors that come in are in your head a lot. But on contact, it's less common. And so in this case, which was a few years ago, Madam Justice Russell called Fawcett and Reed, Ms. Reed had a 9-year-old daughter, and she was not Mr. Fawcett's child. And he wanted contact with this child, and the court said, well, you have the onus of establishing that contact with you is in the best interest of the child. So the onus isn't on Ms. Reed to say it's not in the best interest of the child that you not have contact. It's your onus. And this was an interesting one, because this isn't really the case in when you're talking about parenting time with guardians, is the issue of deference to the custodial parent. So the court said, it is a relevant consideration, subject to all the other factors that deal with the best interests of the child. Oftentimes you'll have a parent who's, when the parties break up and it's not your biological child, your ex might say, well, you don't get to see this child anymore, and the relationship, even if you've had a very long relationship with that child. In that case, the court will say, yes, you have a deference. I give some deference to you as the parent of that child, the guardian of that child. But also, there's other factors that come in. There's a long history of care of the child. There's, their emotional connection, probably the stability that parent offers, and so forth. So deference is, I think, was easier in this case because Mr. Fawcett didn't have a lot of a relationship with the child. Wasn't really even called, the judge says, it wasn't even really a pseudo step-parent, right? Was involved in the child's life a bit, but not so much. So in this case, the judge was more confident in being able to say, I can give more deference to the mom and what she wants. And really what it was it was shortly after separation. It was pretty volatile still in terms of their relationship, the parties' relationships, that she says, this isn't healthy for my child, and I don't think you should. So what the court, though, said was that even though that there was a positive relationship with the child and Mr. Fawcett, it wasn't sufficient to warrant ongoing contact with the child in wake of the breakup, because the mom was concerned about the conflict affecting the child, right? So the judge, though, didn't say, they were in an interim hearing, right? And part of it was she thought if he got some contact, this matter would never go to trial and would never get done. So it wasn't a closing off entirely forever of contact. It was at this interim stage. So once they got to trial, it could be he could have had contact. And also, as time passes, perhaps things are better between the parties. And but that's an interesting one about contact. This next one is from 2017, DD and AC, and it's Judge Cordobash. So DD was the mom, a grandma. AC was the father. Sadly, the mom died of multiple sclerosis. And there was one child. And the grandmother had filed for an application for contact just weeks after her daughter had passed away. And that was at the advice given to her by a social worker with the ministry. Anyway, so Judge Cordobash noted a few things. That it was important. What happened was when that happened, the relations between grandma and dad fell apart even more. And so the grandma had been quite involved in the child's life, and the child had a good relationship with grandma. But because then grandma and dad were not on the same page anymore, grandma wasn't seeing the child anymore. So the judge noted a few things, of course, that it's important to minimize any conflict between grandma and the dad, and because that level of conflict was not in the best interests of the child. The judge again note that when the grandma filed her application just weeks after the daughter passed, it was poor advice given by the ministry to do so, because all it did was further alienate the dad from the grandma and also cause the severing of the relationship with the child. Again, contact has to be in the best interest of the child, and unfortunately, some adults forget this, and the child becomes the means through which adults seek what they consider as their rights. So they use the kids as a pawn with all that, and that's certainly not the best interest of any child. The judge said, look, some time has passed by the time they hit this trial, this court, and probably grandma now realizes that how fragile the relationship can be and is going to try to shield the child from further conflicts. One of the things that the grandma did was, without the father's knowledge or consent, took the child to the gravesite for her mom. And the father was quite taken aback by that because he, I don't know, I think he just it was his decision if they were going to do that for this child. It was the first visit. So that was one thing that caused rift, and grandma, I guess, overstepped, according to the judge. But the court acknowledged that in the midst of tragedy, people often lose their ways and say things and do things that they otherwise wouldn't. And that's what happened here. To hold people responsible forever for their actions at a time when they are emotionally vulnerable is rarely the right thing to do. Although these events affected Ms. D's relationship with Mr. C, there is no reason that it has to affect or damage the child S's relationship with her. And that's, I think, an important thing that we all know, is that when people separate, things happen. And sometimes, and judges are, my clients say, oh my God, this happened. I said, most judges will be like, okay, you just separated, you screamed at each other, you swore at each other. I mean, if it's not an ongoing thing, it's really not going to go very far, and we hope it passes. Like, people say and do bad, people act badly when they break up, oftentimes. And so this is, again, the judge having some acknowledgement that that's what happens. And that's what often will happen in courts. Like, people want sometimes judges to be so outraged that their ex called me the C word or something like that. And, it's a horrible thing, but most judges will be like, okay, if it happened once, that's over, we're done. If it's a pattern, we've got another thing going on. So in this case, the judge applauded grandma for wanting to continue to be part of her granddaughter's life and to try to, but that her use of the courts to do so, right, so shortly after the passing of her daughter wasn't ideal. But the judge was hopeful that the parties could work this out and put the child's interests at heart. The judge did remind the grandma, though, that she is not the parent. And she has some contact, but it's not going to be at the level at which it was before. The father and the child had now moved away a bit. So the grandma did get some contact, 4 hours, 1 day a month, some Skype calls, but the judge was also signaling, I think, with the way that the reasons are written, hope that the father and the grandmother would work their circumstances out, and that they by themselves would increase the parenting time, the contact with S. So it's a nice sort of, it's a very unique situation. It probably doesn't come up very much, but it's sort of an example of taking all the factors, looking at the whole situation and not getting caught into a lot of the details of some of the bad behavior, and say, because a judge might say, look, grandma, that was really crappy what you did, and so I'm not going to let you have any contact at all until you go to counseling or until you do something. I think, but the judge, and I'm not sure how the grandma presented at trial, maybe the grandma was more contrite about what had gone on, and so therefore the parties, hopefully, the judge put something in place that hopefully would help everyone, and especially the child, move forward in a good way. Often we talk about variations, right, of orders, and this is a variation of a contact order. And similar to all other orders, you need to show a material change of circumstance. But I'll get to something interesting at the end about variations and what a material change of circumstance is. So in this case, under Section 60 of the FLA, the court can make an order to change or suspend or vary a contact order. The father had an order from 2012, so we're now in 2015, and the order was for supervised parenting time because the dad was a piece of work at that time. The dad had some open criminal matters going on, had no housing, had no employment for a long time, and was a frequent user of marijuana. Bad, so bad. Anyway, so dad was not in a good shape at that time. But over the years, significant things happened for the dad, and things got better for him. He had a stable job, stable relationship, was in parenting counseling, and he was paying child support. So he applied again, and the children also, their lives changed. They got older, they were involved in more activities. And so the court found that this was a material change of circumstances, all these factors together, right? I think the mom's situation had also stabilized as well. So in that case, the judge found that there were sufficient grounds and evidence to allow the dad to have some unsupervised access and overnight, contact and overnight as well. So one of the interesting things that came up and in this case was that Judge McCarthy talked about the test for the material change of circumstance, and basically said the test in like contact orders are a lot sort of lower. Like the change of circumstance, like he basically was saying this kind of change of circumstance wouldn't necessarily fly if we were talking about changing the parental responsibilities regime, right? Because if at the time mom had all the parental responsibilities and dad says, oh, look, this is the change in circumstance, the judge signaled that in fact he would apply a higher test to determine whether or not there was a change of circumstance in order to vary the guardianship, the parental responsibility orders that were made. So he's just signaling that there's, in each section that has a change of circumstance, it's not necessarily automatically the same test that will be applied. So don't worry that if you go, oh my God, all he has to do is clean up his act up and he's going to now be a joint guardian with me. Judge McCarthy is saying, nope, don't worry. It's got to be more than that.